It's 7 o'clock. I imagine some people are going to keep trickling in, but I thought we could get started. Good evening. Thank you for coming. My name is Gary Arasian. I'm the city's Director of Planning and Development. Sitting to my left is Nick Wiley. He is the city's environmental planner and also serves as the city's conservation agent. So the purpose of tonight's community meeting is to talk with you about the proposed amendments to the Wetlands Protection Ordinance. And just to start off, I just want to emphasize that the purpose of tonight's meeting is a community meeting. It is not a public hearing. The municipal council will be calling for a public hearing, I imagine in the short term, perhaps April or May, I don't know right now. But in advance of that public hearing, we are holding a community meeting, and the goal tonight is to provide you with in-depth information and answer your questions with respect to the proposed amendments. Nick and I have coordinated with the Sustainability Commission to conduct 2 of these public forums, again in advance of the public hearing. One obviously is tonight. The second one is going to be scheduled on, or I should say is scheduled on Monday, March 30th at 7 p.m. also at City Hall. So for purposes of tonight, we prepared a PowerPoint presentation for you. It will outline, it will outline the proposed amendments, why the amendments are a good idea for our city and for the environment, and we're going to talk quite a bit about enhanced protection of the wetlands, resources, water quality, flooding, so forth. We're going to talk about what the amendments mean to you in a practical matter. Homeowners, builders, what does this mean to you? We're also going to talk with you about the built-in amendments with respect to exemptions. We're also going to talk with you about grandfather rights that have been built into the amendments. As far as just a couple of ground rules, Nick and I debated how we should engage you with the questions, whether or not we should ask you to wait until the end, whether or not we should engage you during the process, and we thought the best way is to have as interactive as possible with you. So we're going to invite you to ask questions while Nick is making the presentation. Just a couple of thoughts. I was just going to ask if you could just raise your hand so Nick could acknowledge you, because you might have multiple people wanting to ask questions at the same time. So if you wouldn't mind if you could just raise your hand, and then we would ask if you can come to the podium and ask your questions, because with AACS, they've made it so that we could all hear what the question is. We can hear the question, everyone in the forum can hear the question, plus this is going to be taped so that we could run this session for those residents who couldn't make it tonight, who might not be able to make it for the next meeting, so that we can continuously run this on television until the night of the public hearing. I guess the last point I just want to raise is, so we started at 7. We're thinking about ending this for an hour and a half, or 8 to 8:30, just so we have some structure. That is not to say that you can't continue to ask questions. So once the presentation is done and we're generally completed, Nick and I will still hold back and answer any questions that you have. So having said that, I'm going to hand over the presentation to Nick at this time.
Thanks, Gary. As Gary mentioned, my name is Nick Wiley. I'm the city's environmental planner and conservation agent. So we will get started with tonight's presentation, and thank you all for attending. I do appreciate you taking time out of your night to come here and listen to our presentation. So just a brief agenda so you can see how tonight's presentation will flow. So we'll start off just discussing why we have a local wetland ordinance to begin with, and then talk about one of the most critical components of our ordinance, which is the wetland protection zone. Then we will move into the proposed amendments, talk about the purpose of those amendments, and then we will have plenty of time in the end for questions, comments, concerns, and Gary and I will address those. So leading off, why do we have a local wetland ordinance? Why is it important? So
can everybody hear Nick? I just want to make sure you can all hear in the back. Okay, thanks.
Great, thanks, Gary. So local wetland protection ordinance is important because it helps fill gaps in protection left by federal and state law. Some of you may be asking, what are examples of those gaps? In particular, so with the state's Wetlands Protection Act, that protects bordering vegetated wetlands. So any wetland that is bordering on some type of water body, such as lake, pond, stream, the ocean, What our wetland and ordinance does differently is that in addition to those bordering vegetated wetlands, we also protect isolated areas. We also have increased protection for vernal pools. Under State's Wetlands Protection Act, vernal pools need to be certified by Natural Heritage Endangered Species Program, and then they would get 100 foot of regulated area. However, that regulated area stops within a wetland. Attleboro's ordinance, that 100 feet, 125 feet of regulated area extends no matter if it's a wetland or an upland to help preserve a vegetative buffer around the vernal pool and keep its protective interests going in perpetuity. Additionally, we also protect ponds of any size. So Wetlands Protection Act, to be classified truly as a pond, it has to meet certain square footage requirements. So ours, it does not need to meet the larger square footage requirements of the Wetlands Protection Act. So we can protect more of those isolated wetland areas. Additionally, our ordinance, or wetland ordinances in general, allow communities around the Commonwealth to apply additional performance standards to protect the values that they deem most important in their communities. So what is the wetland protection zone? So as I mentioned before, it is the most critical component of Attleboro's local wetland ordinance. What that does is it identifies the area that is abutting or adjoining within 25 feet of any of the protected resource areas that are identified in section 1.3 of the ordinance. So that includes any wetland, pond, stream, vernal pools, land subject to flooding, and others. We have two different types of land subject to flooding. That would include both bordering land subject to flooding and isolated land subject to flooding. Typically, that is defined by FEMA's 100-year floodplain. However, in cases where you have isolated land subject to flooding, there is certain requirements that it has to have at least 2,000 square feet of area and also hold 6 inches of water within designed storm events.
Nick, and that 25-foot WPZ that's currently in the ordinance, that's within the 100-foot regulatory buffer of the Wetlands Protection Act. It's not in addition to, but it's inside that 100 feet, correct?
Correct, yeah.
Okay.
So circling back to some of the state protections, just to provide a little context to what Gary's mentioning. So we have our local wetland ordinance, but then the state has the State's Wetlands Protection Act. So that assigns a 100-foot buffer zone. Attleboro's local wetland protection zone is contained within that. Both the 100-foot buffer zone and Attleboro's local wetland protection zone start at the limit of a wetland or other protected resource area. Moving on, so, yes.
Jim, could you come to the podium, please?
Yeah. We just want to make sure anyone that's on the live stream can hear you as well.
Jim Lewis. With the vernal pool, it's my understanding that the 25 feet, so with the vernal pool, you've got a 100-foot protection zone. The 25-foot or now the 50-foot is within that 100 feet or on top of it?
So we're clear, you're talking about just the local ordinance and not the Wetlands Protection Act, correct, Jim?
What I'm saying is in Attleboro, if you're within 125 feet of a vernal pool right now, you're very limited in what you might be able to do. Will it now be 150 feet?
So the answer is yes.
Okay.
So for context, the way the ordinance defines a vernal pool is not just the pool itself, but any of the land that's within 100 feet. And then just below that, in the area that identifies the resource areas protected by the ordinance, it says any lands within 25 feet. So that is where we get 125 feet of protection for vernal pools. And I will get to this later when we talk about the proposed amendments, but what Jim was mentioning is how we are proposing to increase the wetland protection zone from 25 feet to 50 feet. So therefore, vernal pool protection would go from 125 feet to 150 feet. So what the ordinance states about the wetlands protection zone is that the land within that WPZ is presumed significant to the protection of the wetland resource areas identified under the ordinance. So alterations to that area may require a permit from the Conservation Commission. And what the ordinance states is that when anyone is submitting an application to the Conservation Commission, that the Commission may require a strip of continuous, undisturbed vegetative cover in part or within all of the WPZ. Now, in the vast majority of circumstances, When we get an application, we have not been to the site yet, which is why we require you to show that undisturbed 25-foot strip, especially when it pertains to new development. Now, there's going to be nuance to this because there's plenty of properties that are already within the wetland protection zone. In those cases, if you're filing for an application, you still have to show the wetland line, but it does not necessarily mean that wetland protection zone that already exists on your property is immediately some no disturb zone. So when the commission is reviewing areas or applications that are within our jurisdictional wetlands protection zone, and looking at the proposed activities that property owners are proposing, we're going to be looking at that in terms of four broad forms of disturbance. These would include no disturbance. So that is where the Conservation Commission has found that the area is so significant to the interests of our local wetland ordinance that there should be no disturbance of that area in order to protect the values. Then there's cases where there's temporary disturbance. On occasion, someone may need to move heavy equipment through the wetland protection zone in order to access an area for construction or other temporary activities. So that's an example of where they can allow a temporary disturbance. And then there's limited disturbance and permanent disturbance. Now, permanent disturbance, there's many cases of that already where you have existing homes, driveways, especially roadways that are already within there. But when reviewing things in the context of a permanent disturbance, the commission may find that there are aspects of that wetlands protection zone that are not providing any of the values or protecting any of the interests of the ordinance. So in the case of, let's say you have a place that's already developed and you have a parking lot that's partially within the wetland protection zone. The commission may determine that the asphalt there is not protecting any of the interests of the ordinance, such as wildlife habitat, flood control, prevention of pollution, things like that, and allow the redevelopment within that portion of the wetlands protection zone. And so the key thing about the ordinance in the wetland protection zone is that it is presumed significant, but the presumption may be overcome with the preponderance of credible evidence. So it's a case-by-case basis, depending on the site and what you're proposing, to overcome that presumption of significance. So that is, those regulations and standards and language are already in the ordinance today. We're not proposing to change that aspect of, regarding the presumption of significance. But we are proposing to increase the wetlands protection zone itself. So now we will get into the actual proposed amendments to the ordinance. So as was mentioned before, and one of the most critical components is increasing the wetland protection zone from 25 feet to 50 feet. Additionally, we are proposing to increase the length of extensions allowed for local wetlands permits from 1 year to 3 years. On top of that, we would add minor activities section that includes additional allowable activities under section 18-1.8 of the ordinance. Currently under there is 3 activities listed as sections A, B, and C. The first one is allowing passive use of the wetland protection zone. The second would be allowing access through the wetland protection zone to access upland areas. And then the third is allowing development adjacent to land subject to flooding within that wetland protection zone. So we would be adding on top of that some of the following minor activities. These would include repairing or replacing an existing septic system, installing unpaved pedestrian walkways, installing fencing and stone walls, vegetation cutting for road safety maintenance, limited to the following. That would be removing diseased and damaged trees and branches that pose an immediate and substantial threat for driver safety by falling onto the roadway, removing shrubbery and branches to maintain clear and visible guardrails. Such work shall extend no further than 6 feet from the rear of the guardrail, removing shrubbery and branches to maintain clear sight distance at existing intersections, and removing shrubbery branches and other vegetation required to maintain the clear visibility of road signs and traffic signals. Those last few points primarily maintain to city rights-of-ways, and it's language that's similar you would find for the Wetlands Protection Act. The idea behind that is to ensure that we're having right-of-way maintenance plans submitted to us specifically by DPW or other entities, in providing an avenue that clearly states in the ordinance where we may allow that activity. And then regarding the, circling back to the length of extensions, currently, if you were issued a order of conditions, which is a type of permit under the Wetlands Protection Act, you're currently already allowed to request 3-year extensions under those type of permits. So to provide some parity between the local wetlands ordinance and the Wetlands Protection Act, because the vast majority of cases, if you need a local wetlands permit, you also need an order of conditions on the Wetlands Protection Act. We want to provide parity between the permits, so if you have a long-term project, sometimes major infrastructure projects may take more than 3 years, or projects may not get started within the first year of a permit being issued. So we want to provide some flexibility and allow the commission to provide greater extensions for a local wetlands permit under the ordinance jurisdiction. And then fourth, we have the exemption section, which is really one of the biggest changes aside from increasing the wetlands protection zone to the ordinance. Previously, there was no definitive exemption section. The only thing that
So when we talk about previously, let's just make it very clear. As all of you know, or the majority of you know, that this proposal was made several years ago under the previous mayor's administration. And what Nick is referring to, when that proposal was submitted to the municipal council to amend the ordinance to increase the WPZ from 25 feet to 50, in that proposal, there weren't any exemptions or grandfather rights. So when Nick says previously, I just want to make sure that we're all clear that that was the previous ordinance amendment that didn't go through. In fact, I don't recall if it was withdrawn or what ultimately. I know it just never was adopted. So this version, all up front, we've built in exemptions and grandfather rights, and there's a critical one at the very end that we'll talk about a little bit more. So I just want to give a little context to when he says previously, it was to the previous proposed amendment, that this one includes as part of the proposal to increase it from 25 to 50 feet, that there are built-in exemptions and built-in grandfather rights.
Yep. Thanks, Gary. So regarding some of those exemptions, I don't know if everyone wants to hear me list them all one by one. I'd be happy to do that, but I think just for the sake of brevity, I'll list some of what I think are the most important ones, especially as they apply to many of the homeowners here in Attleboro. So one of the first exemptions that we've listed is additions to existing single-family homes, provided that the addition is within a previously disturbed area, such as an existing lawn, driveway, or deck, and further provided that any work within 25 feet to the nearest wetland resource area shall still require an order of conditions and any other relief hereunder. So while we may be able to provide exemptions on the ordinance, we cannot provide exemptions under the state's Wetlands Protection Act. So that is what the order of conditions is referencing there. So what that means exactly is if you have your house, you're within the 100-foot buffer zone of jurisdiction to the Wetlands Protection Act. However, your proposed addition would be more than 25 feet away. You would not need to file a local wetlands permit application. You would only need to file under the state's Wetlands Protection Act. However, if you were proposing the addition within 25 feet of the Wetlands Protection Zone or the wetland itself, then you would need to file a local wetlands permit in addition to that order of conditions. And then it would go through a review process with the Conservation Commission. Next, we have reconstruction, remodeling, or maintenance of existing single-family dwellings and accessory structures where legally pre-existing, provided that the footprint of such dwellings and structures remain the same. So if you are re-siding your house, putting new windows in, putting on a new roof, that does not require you to file an application with the Conservation Commission. John, come on.
John DeVerns, 88 Richardson Avenue. If we could go back to the exemptions, you stated specifically that it's the exemption applies to the areas that are previously disturbed.
Yep.
So what happens if you have if you're a homeowner in your backyard and it's an area that's not previously disturbed? what's the metric that determines between disturbed and not disturbed? Because you have written driveway, backyard, lawn. What if you have a stand of trees? And if you could answer that.
Yeah, so if there's a stand of trees, I mean, the first thing that I would ask if someone, prior to them filing the application is this a landscaped area that is continuously maintained? Like, let's say you have it circled around with mulch and stones, it looks like it's clearly not natural. Then, in my opinion, okay, that's a maintained area. That's not the natural undisturbed that we're looking for. But if you have an undisturbed area where it looks like it's very much natural, it's not a maintained area, then if it's within the 50 feet of it, you would need to file a local wetlands permit application for review.
Okay, thank you.
Touching back on the reconstruction, remodeling proposed exemption. So that's not something we currently regulate with the Conservation Commission right now. In my time here, we've never required an application for a roof replacement, windows replacement, or residing or repainting. And the reason for that is because that's not an alteration of land. You are maintaining a structure. So it's not something that we deem a regulated activity, but it's never been explicitly stated in the ordinance that that was unregulated
And if
or
we would,
exempt.
and if we were to increase it to 50 feet, that would continue to be the case.
Correct.
It would be exempt. You
Yes.
would not have to file. Okay.
Yes. So keeping with the theme of reconstruction, remodeling, and maintenance, we're also proposing that those would apply to structures where legally pre-existing other than single-family dwellings. So if you have commercial property, or maybe you have a multifamily dwelling, you get to continue to remodel that. Again, that's not something, or do proper maintenance on it. That's not something we regulate currently. The only time that regulation may apply in that situation is if for some reason you had to take a piece of heavy equipment into a wetland, because I know there are buildings that sit very close to the wetlands in certain areas of the city. So if you had to provide heavy equipment into the wetland, well, now you're altering a wetland, that wouldn't be exempt. Wouldn't be exempt under local ordinance, wouldn't be exempt under the Wetlands Protection Act either. Moving on, we have converting existing lawn to decks, sheds, patios, above-ground swimming pools, replacements of bulkheads, installing a handicap ramp for ADA compliance purposes and other reasonably similar uses, provided that any work within 25 feet to the nearest wetland resource area shall still require an order of conditions and any other relief required hereunder. So this is very similar to what you would find defined as minor activities under the Wetlands Protection Act, and therefore not requiring a notice of intent. The exception with some of that is under the Wetlands Protection Act, for example, swimming pools. In order to be defined as a minor activity and exempt there, you have to be more than 50 feet away and in the lawn area. Ours, we're saying at least if you want to be exempt under the ordinance, you just need to be a minimum 25 feet away and then in the lawn area. So there's a slight difference with how that's applied. So we're trying to be as understanding as possible, is that when someone has a home, there's high likelihood that there's going to be accessory structures that you may want to put on there or improve upon. So we have an exemption to try to cover some of those cases. Next would be converting existing uses accessory to residential structures, such as those described in the above section that I just listed, to lawn. So if you have an existing pool, like shed or patio, if you have no use for that anymore and you just want to convert it into lawn, you'd be allowed to do that without a local wetlands permit. Next, we have repairing or replacing unpaved pedestrian walkways, provided that the existing footprint of said walkway is not increased. That's a common question I've gotten a lot over my 10 years here with the city. Very basic maintenance projects like that on an existing, walkway, no matter what, whether it's, stamped concrete, bituminous pavement, could be cobblestone, it could be gravel. As long as you're maintaining the existing footprint and you want to continue the maintenance, especially depending on the property, proper maintenance of a walkway is going to be a liability issue. We understand that. We don't want to prevent you from providing safe passage over your property. So that would be an exempt activity as well. Next, we have Repairing or replacing existing fencing and stone walls, provided that the existing footprint of said fence or stone wall is not increased. That's another common case I get all the time. If you want to do a one-to-one replacement, to me, you're not creating any additional alteration that hasn't already been approved or was pre-existing to the ordinance being enacted. So that would be an exempt activity, provided it's not running afoul of anything within the Wetland Protection Act. Next, we have mowing existing lawns and maintaining existing landscaped areas, provided that no yard waste and cut grass clippings are disposed of in the Wetlands Protection Zone. So, in my time here, we have never, ever regulated the mowing of a lawn. The only exception would be is if you had some type of old agricultural area or you had an old lawn that sat dilapidated for a number of years to the point where it doesn't look like a mowed lawn anymore. Because I know that question has come up to me in a couple of times where, well, it was mowed 5 or more years ago. Well, it does get to a point where now it is going to get revegetated and start to form into a more natural area. So we have to make a distinction between that. But at least now it would be actually codified into the ordinance that you can continue to mow your lawn as it exists today. It's not a regulated activity. Now, if you wanted to expand your lawn, that may become a regulated activity, but at least proper maintenance of your yard as you've been continuing to do so the whole time you own your property is explicitly listed as an exemption. Next, planting native species of trees, shrubs, or ground cover within previously disturbed areas. This exemption, however, does not include the installation of turf lawns within previously undisturbed and vegetated areas. So, for instance, you wouldn't be allowed without an application to go into a forested area of the Wetlands Protection Zone and just convert that to lawn. But if you want to plant new plants within your lawn area, within a previously landscaped area that is clearly being maintained, you can do that without a permit. That's not something that's been regulated in my time. If people wanted to plant new trees, the Conservation Commission encourages new trees and new shrubs. We only ask that you're not planting anything that's going to be invasive and potentially create a nuisance for the community. Can you go to the podium, sir?
Just a question on the invasive, because I've got some of that wisteria growing along the side of my swamp, and I've been tearing that up. Mm-hmm. That doesn't, I don't have to go to ask you guys about tearing out the old shrubs, do I? The wisteria and these other invasive vines that are growing in there?
So the way it comes to tearing out invasive species is, what I will say is it really depends on the amount that you have and what that would, like if it's 1 or 2 plants and it's not going to make some substantial impact, generally I would say you likely don't need to file an application. Okay. But there are times where, especially if you're dealing with, say, Japanese knotweed, where it grows in thick, it grows in so much that in order to remove it, you're either having to do 2 things. You're either having to dig out the entire root system to make sure there is absolutely nothing left, which is certainly going to cause an alteration as defined under the ordinance, or you're going to have to use some type of herbicide, which we would prefer to avoid, but depending on the severity of an infestation, it may be required. But that's when, if you're using an herbicide within one of our regulated areas, then we're going to need a review and an application with the Conservation Commission.
And that's of the regulated area, okay.
Yeah.
Thank you very much.
Next. Yeah, converting impervious surfaces to vegetative surfaces, provided no exotic or invasive species are planted. And then we have installing, repairing, replacing, or removing signs, traffic signals, sign and signal.
So Nick, can you back up to the impervious? Yep. Can you restate that? Could you be a little more clear?
Oh, sure.
What is the exemption there?
All right, so converting impervious surfaces to vegetative surfaces. So let's say you have old pavement, or even an old building of some kind on your property. You have no use for it anymore. You want to convert it into a vegetated area. That would be an exempt activity. Taking away impervious area is only going to be beneficial to the ecosystem, especially as it pertains to protection of our wetland resource areas. We don't want to hinder restoration of properties. We want to encourage that. And now, we're trying to encourage restoration further, and actually there is an ordinance committee under the Conservation Commission that is looking at some ways at how we could tweak our ordinance further to promote more restoration. So I hope I'll be able to give some better presentations on that in the not too distant future. But this would be the first start, is at least providing an exemption for converting impervious surfaces to vegetated surfaces.
Okay, great.
And just going back to installing, repairing, replacing signs. If you have a sign that's existing and you want to repair it, it's likely not going to require an alteration to any of the regulated areas here. So that's why we're including that an exemption. And plus, our Department of Public Works needs to be able to maintain traffic signals in an efficient manner. So we want to explicitly state that repairing those, replacing those is also an exempt activity. Now, there is some additional caveats to that, though, is that it has to be along existing paved roadways and their shoulders, and provided that work is conducted as far away from the resource area as practicable, but no closer than 10 feet at any time. And that section, but that would only apply to work done on behalf of a local, state, or federal government. Generally, there's no private traffic signals here, at least that I'm aware of. Someone please correct me if I'm wrong. So I don't think that one's really going to touch upon the vast majority of our residents here as far as work they may or may not be doing. But certainly we have plenty of commercial business owners that want to be able to maintain the signs, to have proper advertising. So we want to take that into account. Next, that'll be a big one for people is pavement repair, resurfacing, and reclamation of existing roadways. So that is, again, something that's already exempt under the Wetlands Protection Act. So just providing some parity with that. If we have an existing roadway, we want to make sure that our Department of Public Works can fix it and not have any undue hold up with that. And then lastly, we have repairing, resurfacing, or replacing existing driveway, provided that all work remains within the existing footprint of the driveway and all surfaces are permanently stabilized within 14 days of completion of work. So what do we mean by permanent stabilization? Typically that means you have some type of vegetation that is preventing any of loose material from eroding away, especially during a rainstorm or anything like that. There are other forms of permanent stabilization, and sometimes you need temporary erosion controls such as silt socks, maybe a silt fence. Depending on slopes, you need some jute netting to actually get yourself to permanent stabilization. But I'm always happy to talk to people about how to reduce erosion and sedimentation for getting into the wetlands.
But Nick, can you talk a little bit more about the driveway itself? What is it about what is it about the driveway improvements that would be exempt?
Yeah, so let's say you have your existing driveway.
Within where, within the 25 feet?
Yes.
Okay.
Yeah. So if you're within any part of the wetland protection zone, so we did not put a caveat if it's more than 25 feet or anything like that, because again, there's a lot of existing cases of driveways within 25 feet already. They've been there for years. They pre-existed the ordinance. They probably pre-existed the Wetlands Protection Act. As long as you are replacing it in kind with no expansion, you would not need to file a local wetlands permit application under the ordinance.
If the ordinance were increased to 50 feet?
Correct.
Okay.
Yeah. All right. So that covers the exemptions that we are currently proposing. I just wanted to touch upon, I'm sure there's many questions of why are we doing this? So the primary purposes of this are to provide better protection of our wetland resource areas. So we've had 25 feet now for a number of years. It was a good start, but it's not enough if we want to provide the level of protection that we seek, especially as we experience warmer summers. So we're losing more water to evaporation at times, but we also have a number of water quality issues from a lot of the existing roadway and impervious area. As it rains, all that rainwater is collecting all of the pollutants that are off any of the impervious surfaces, and in the vast majority of cases, the stormwater is then discharging into wetland areas. But when we're looking at stormwater pollution, we have two forms. We have point source pollution and then non-point source pollution. So point source pollution is any of the stormwater that's being collected from a pipe and then discharging from that pipe. It's a very simplified way to explain it. But the most pervasive form of pollution we have is non-point source pollution. And non-point source pollution is all of the runoff running over land and then just sheet flowing into our waterways and other wetland resource areas. Providing a larger wetland buffer as it pertains to especially new development projects. There's nothing, the city cannot require someone who has an existing disturbed wetland protection zone to just increase that. But in the cases of, let's say someone has new development projects, like a new subdivision, or someone's going to some otherwise currently vegetated area and proposing some work. A 50-foot wetland protection zone is going to provide better filtration of that non-point source runoff than a 25-foot. Now, that's going to be a case-by-case basis. There is nuance to that, because depending on the topography and the amount of vegetation there's going to be different levels of effectiveness. I do understand that, but the vast majority of the research that's out there, less than 50 feet is generally ineffective at filtering of the pollutants in the runoff. So that's why we're proposing to go to 50 in that sense. And then additionally, the greater wetland protection zone will prevent greater impact of heat island effect. If we can preserve more of an existing tree canopy, then we can provide better protection of some of our water resources by preserving more of the shade that's in there. And then additionally, the more vegetation we can preserve in that wetlands protection zone, we can also potentially reduce further impacts from flooding just by keeping those mature trees that are going to be able to soak up a lot more water than any of the new trees that may be planted.
And Nick, isn't it true that we could anticipate greater volumes of water because of climate change, that we could expect more frequent rainstorms and of greater intensity?
So we can expect more high-intensity rainstorms. So we used to get more storms that were dumping smaller amounts of water at a time. But now we get closer to 100-year storm events more frequently now. And I'm sure everyone in this city has seen flooding in the not-so-distant past in various places around the city, especially along County Street and downtown, and in various areas in South Attleboro, such as Tomlinson Avenue.
Carlton Street. Downtown Attleboro?
Yep. Yeah, County Street, yeah, where the 10-mile river comes underneath County Street and downtown. So the intent is if we can preserve some more vegetation within our wetlands protection zone, then maybe we can reduce the impacts of flooding to some extent. We're not going to solve our flooding problems with this alone. I understand that. But preserving vegetation certainly has its merits when it comes to flooding in the future.
Can I ask again?
Okay, yeah.
I'm losing a bunch of beech trees due to the blight that's going on.
Mm-hmm.
Now that I'm not really registered on the swamps, but I live next to a swamp, and so that majority of those beech trees are dying with the blight. Do I have to go? Should I go to you and say, could I put up some oaks, or what am I supposed to do about that? Just let them die and let the nature take its course, or?
I mean, if they're already dying.
Well, the beech are, yeah, they're
Yeah,
gone.
I mean, if they're already dying and you know there's no hope of saving them,
Yeah.
then it's probably in your best interest to replace them with something that's going to be more survivable in the future.
Okay.
It'd be good if especially if you're doing something that's either disease tolerant, drought tolerant, or something that's not being attacked by some of the invasive insects that we have. Like we have the emerald ash borer, so I wouldn't propose any ash trees or anything like that.
Okay. All right, but yeah, it was just one of those things, just going, okay, I wanted to think about
Yeah.
the beech trees.
Yeah, but let's say if they were right up against the wetland, in those cases, I would say, let's schedule a site visit so you can show me exactly, what it is you're proposing. In a lot of the cases where if it's just, say a handful of trees, the Conservation Commission allows me to use an administrative approval for just various trees, especially if those trees are posing a hazard to your house, various parts of your property. So I know that's something I didn't touch upon before, but it's a common question I get all the time is, do I need an application to take down trees? And so really it depends on the amount of trees, but There's various trees that are going to become a hazard prior to a storm event, where you can see there's clear bug damage. It's either already dead or it's rotting in a lot of places. In the vast majority of the cases, you don't need to file an application for that. The way we handle it with the Conservation Commission is schedule a site visit with me. Just have me look at the tree, let me see what you're proposing. Usually, if it's completely dead, I'm going to agree that yes, it's a hazard and it needs to go. We would like to see the tree come down before it falls on someone's house. There's also been cases where people show me the letter from their home insurance company, and it says, we're going to drop your insurance unless you get rid of this tree. I take that very seriously. And if that's the case where you have your insurance company threatening that, then in that case, I'm not going to have you file an application. We're going to have you proceed with getting rid of the hazard tree, and so you can keep your home insurance. Joe?
We'll talk about grandfather rights or anything like that.
Yeah, we'll touch upon that, yeah.
Joe Kaepernick, I live on Pike Avenue. I've got some clarity on the exemption in the 25 versus 50. When the 25 was first put in, it was put as a no disturb zone, I thought.
So that is a common, everyone refers to it as a no disturb zone. And I will tell you, there's been plenty of members of the Conservation Commission that refer to it as that as well. But that is because of the presumption of significance, as it's stated in the ordinance, is that we always presume the wetland protection zone is significant and should not be disturbed, but it's going to depend on A, what's actually there, and then what are you proposing as an activity? Now,
Okay.
generally, if like, Joe, like if it's a completely undeveloped property, the vast majority of the time, we're going to assume that's significant and it shouldn't be disturbed. Not to say you can't try to present evidence, credible evidence that says it's not significant to the protection of the wetland resource area values. But if you have an undisturbed natural area, I think it's going to be tough to overcome that presumption.
So even in the 25-foot now, or if the 50 does become law, you can come to the Conservation Commission with a project, whether it be minor or major, and it can be determined that it is allowed.
Yes.
So
That
it
language
is
is already in the
automatically
ordinance.
rejected.
Yeah.
Okay, thank you.
So, I mean, the language is, because it's a lot of legal language, it's very careful where it says the commission may allow.
Yeah.
Things like that. And then in section 1.8 of the ordinance, where it talks about permits and conditions, it says when you file an application and a site plan, you have to show that 25-foot of strip of continuous and undisturbed vegetation on your plan, unless the commission determines that either a portion of it or all of it is not actually significant to the protection of the interests of the ordinance.
Okay.
So that's always been the case, but because the commission wants to be protective of wetlands, it's typically been marketed as a no disturb zone, unless someone can provide the credible evidence.
Yeah, that was my misunderstanding then on the.
Yeah,
Okay,
and,
thank
and
you.
then I also want to just touch upon, Joe, because I think this really segues into some great other things. When it comes to, especially like a permanent disturbance, we want to make sure that if the commission is going to allow a permanent disturbance of the wetlands protection zone, we want to make sure that whatever that activity is not going to result in cumulative adverse impacts over time on the ordinance. So to kind of explain that further, if we were to allow a house within 10 feet of the wetland to be constructed, more than likely what's going to happen is at some point, the homeowner is going to want to start either trimming or fully cutting the trees that are growing out of there because of how close they are. Eventually the branches are going to grow out and touch the house because the trees are just going to grow towards where the most available light is. It's just a fact of what's going to happen. And so eventually that is going to create some cumulative problems over time because they're going to want to keep having to cut that tree back, and it may get to a point where the tree dies as it keeps getting cut. If that's the case, then we're looking at cumulative impacts now, because if you cut some of the trees that are actually in the wetland in order to protect the house, now you're reducing all the shade of that wetland, and then it could dry up, and the plants that are in there that are typically requiring more shade are not going to be able to survive, and then there's other impacts on any of the local fauna that's in there as well.
So basically, it isn't a no disturb, but it is a more highly regulated if you are proposing something within the 25 existing now. Okay.
Yeah.
Well, it wouldn't be any more regulated, right? It's not going to be any more regulated. It's just whatever's regulated now within the 25-foot where the commission has discretion. That would just extend out to the 50 feet. So that that the same amount of regulation is there, it's just would extend out 50 feet. And it's discretionary to a certain extent.
So we haven't increased the performance standards or,
Right.
we haven't said like, oh, you need additional X, Y, and Z to forget that credible evidence. But
It's
we,
the same standards.
yeah.
Thank you.
John, 1 second, there's someone coming. Come on in.
Hello, my name is Patricia Belfield. I live on Newport Avenue. I had a question in regards to new construction. I work in the real estate business for 20 years, still in a business. Worked as a consultant on a new development in Boston. And when they were building on wetlands, they didn't anticipate that the water backed up in people's homes and it caused a huge problems. And they had to, I think they had to go to the city and try to see if they could get sub-pump systems to keep the water from running into their homes. So I wanted to know, would that be something that you guys would consider, maybe having a sub-pump system so this doesn't happen to people who are developing new homes in Attleboro?
So when it comes to sump pumps, I mean, that is really going to be something that cannot be regulated by the Conservation Commission. Because now we are getting into, building code regulation. So the Conservation Commission is limited into what we can regulate. So as far as under the wetland ordinance, it has to relate to the wetlands themselves. Now, the Conservation Commission also administers the city's stormwater management ordinance. But there are, exemptions in that ordinance about, what's actually regulated and what's not. But generally, anything that's going on in the interior of a home is not regulated by the Conservation Commission. That's going to be building code, potentially health department. So we wouldn't be able to require anything like that. But at least in my time here with the city, we've never allowed a physical building on the wetland itself. I mean a structure. The only time we've allowed direct alteration of a wetland is if you had to build a roadway or a driveway to access an upwind area. But if that's allowed, what our ordinance requires is that you have to replicate that wetland with a 1 to 1.5 mitigation ratio. And then you also have to, so that new wetland that you're constructing has to be attached to the same wetland that you were altering. And there's also requirements that you also have to mitigate any of the flood storage as well. So try to prevent any exacerbation of flooding, making sure that that flood water is not going to get pushed onto a neighbor or things like that as it relates to an alteration to the wetland.
All right, that's good to know. About the 50 feet, so you said the 50 feet is already within the guidelines. So if the 50 feet.
No,
That's within the 100-foot regulatory buffer of the wetlands protection.
So it's already in there, right?
It's inside of that, yes.
So the purpose of tonight's meeting is just to let everyone know, or this is something that has to be approved through council?
It will, yes.
Yeah, so this is all something that has to be approved to council, but we wanted to provide, I guess, a less formal setting than the council, where we can respond and answer the questions. I can present exactly what these amendments are, and just have a little bit better forum of addressing what these amendments are prior to getting to the public hearing. Now, of course, everyone that's here, I would encourage you attend the public hearing before the council, because they will be the ones who ultimately will vote on these amendments. But this also gives us an opportunity where if you have any genuine concerns about this, we want to hear them. If there's anything that you think could make these amendments better for the residents that live and work here, we want to hear it. There may be something that we didn't account for, and we tried to account for some of the most common cases with the exemptions, trying to make this, as fair as possible, but also, making sure that our priority is protecting the wetland resource areas here now.
Thank you.
So Nick and I, we're not omniscient. I think we're good at what we do, but there's always going to be feedback where we're going to say, geez, we didn't think of that we could, when we go to the public hearing, recommend to the municipal council to modify some language to account for something that we just didn't consider. So that's one of the reasons for this. Also, to take the top off, one of the recommendations that Nick and I are going to make, I'm jumping ahead just a little bit, but hopefully I'd like to think it's going to be good news on your part, is one of the other amendments that we're going to recommend when we go to the public hearing is the effective date of this proposed amendments. So should the municipal council adopt the amendments as is, as modified, that we might bring some more amendments to it, They may change it because they can during the public hearing process. One of the amendments that Nick and I are going to recommend at the night of the public hearing, and I notice there are a couple of councils here right now, is the effective date. The effective date is typically the date the council takes the vote on. And to be fair to the public, several members of the public might already have engineering plans under design, under the current ordinance. And should the effective date be the date the council takes the vote, one could argue, well, that's not fair because we've already invested X amount of dollars in preparing engineering plans, drainage calculations. So one of the suggestions that Nick and I are going to offer to the council that night, let's see if it's embraced or not, is that there be an effective date of maybe 6 months out. So that if the date was, making this up, on June 30th, that the effective date of the ordinance be December 30th. And that also means that if you file, so you don't have to have your project built, even if you file on the last day of the 6th month, that would be grandfathered. So your application would fall under the current ordinance. We think that's fair. We've heard feedback, and again, I'd like to think we're reasonable. I mean, we certainly wear the hat of the city to protect everybody's best interests. This isn't anything just for the commission, it's for the environment of the city. But we also understand there's a great measure of fairness as well. And there could be numerous examples whereby people have spent money to design plans under the current rules. So we're going to recommend, ultimately, again, it's the city council's decision, but we will urge them, hopefully, and implore them to make the effective date within 6 months. And again, it doesn't mean that you have to complete your project in that 6-month period. Again, I just want to reiterate, because I think it is important that if you were to file on the last day of that 6th month, in that 6-month period, that would carry over.
No, I definitely agree. I mean, I'm in the real estate business, so I understand how it works. So that sounds fair. Thank you.
Okay.
And just to also provide a little more detail on that. So when we say file, that means submitting a complete
Yes, I'm sorry,
application
yeah.
under the Conservation Commission's instructions that can be found online. So that includes the actual application form itself, completely filled out, your certified list of abutters, your site plan, all the necessary number of copies. So as long as it's deemed a complete application and filed before that effective date, you would be grandfathered underneath the current local wetland ordinance regulations. Moreover, if you have an order of conditions issued under the Wetlands Protection Act currently, in that order of conditions, it was showing that you were staying outside of the wetlands protection zone, or actually, even if you were, you may have had a local wetlands permit with it as well. If you have an active permit that was issued by the Conservation Commission authorizing, any sort of work or alteration, if that is, still valid, so it hasn't expired yet, prior to the effective date, then you would be able to continue that project as well. Moreover, you could still request extensions. So as long as it does not lapse, then you would be grandfathered. Yes.
Hi, I'm Rachel Benavides. I've lived in Attleboro most of my life. So I just wanted to comment on how you came upon making that change to give that extension. I'm privy to the conversation that happened, and I'm just extremely proud of, people coming from different points of view and voicing what their concerns are, and then problem solving together. So I just wanted to give kudos to the people that actually had conversations in a bipartisan, way that
Collaboration.
Yeah. Because we're about making this town, this city of ours, better for everybody, and it's not to hurt one side or the other, or there aren't sides. We're all a part of the community. So I just wanted to say how proud I was just to know about this conversation and that we can do this. There was no question.
That's all right.
Thanks, Rachel.
So anything else you want to present, or you want to just open up for Q&A now?
I've just opened up the Q&A.
All right, so I just asked Nick if there was anything else he wanted to present. Probably there isn't, so we're open to questions. Maybe as you ask questions, there might be some more discussion. We could make some more presentary comments, but the floor is open now, folks, if you want to come up in an orderly way. If you could- Again, I kindly ask if you could just raise your hand so we have some order, and we'll invite you up. And in the meantime, I'm taking copious notes of your comments, so if there's anything that we think that we could modify the ordinance to improve it, we'll certainly take that into consideration. So I think I saw, so I don't, okay, gentleman in the back, Mr. Brooks?
Good evening, Jay Brooks. I know you all pretty well, yeah, I just wanted to mention one thing that I thought would be a useful thing to consider for the ordinance as well. When we had a situation with the property beside me where there were some enforcement orders that were placed against the individual that had performed work, and because they had performed their work without having an initial plan. They were in that wetland protection area.
They didn't have a valid order of conditions, correct?
Correct,
Yeah.
and there was an enforcement order issued, but because they had already done the alterations, there was never an initial abutters notice that went out to the neighbors when that happened, because there was no permit filed for that. They never did a local wetlands permit. I think it would be useful if, when there's an enforcement order that goes out, that the abutters be notified of that as well, because there was no chance for anyone to get involved early on in the process and have any type of input. And that could have saved us a lot of headaches had there been a notice early on. So that's just something that I would suggest.
Yeah. What I would say is that the reason right now why there is no abutter notification requirement for enforcement orders is because depending on the violation, it may require immediate action, which if you have to notify abutters and then however long it takes time to do that, it may cause further harm to a wetland, depending on the severity of the violation.
Understood.
So that's why there's no abutter notification requirement for that. However, when the commission issues an enforcement order, depending on the severity of violation, the first thing they could do is, okay, first you have to cease and desist the activity, and then you have to stabilize the area, just to prevent further harm. So especially if you have a steep slope that's adjacent to the wetlands, we want to make sure there's no debris or material that's going to continue to run down into wetlands and potentially fill it in. But depending on the activity they were doing, like let's say, they caused this disturbance because they wanted to build a garage or something like that. The enforcement order can then require them to file the notice of intent in order to get the proper permit necessary to complete the construction. And then at that time is when the abutter notification would happen.
Yeah, and obviously that did not happen with the prior construction that went on beside me, so I'm not sure if there's
Yeah.
any type of way to automate that, maybe after the stabilization, to have that happen automatically, if there's, but that's the idea.
Yeah, but the reason that construction was able to proceed, Jay, is because they had showed plans where they were outside of jurisdictional areas. So those were isolated wetlands that were only subject to jurisdiction under the local wetland ordinance, therefore only 25 feet. On the initial plans they had filed with the building department, they showed they were staying outside the 25 feet. Now, unfortunately, they got a little overzealous, and so now we are addressing that with an enforcement order. So the areas that were disturbed within the wetland protection zone will be restored.
So the way I understand your question, I think that's a general comment of the administration of the wetlands protection and local wetlands, but not specific to any of the amendments tonight, correct?
No, it was
Okay.
more of a statement,
General.
hey, would there be a possibility to, because I actually like most of what was proposed there. I was just, I just happened to say, hey,
wanna
would
make sure I
there
get your
be a way
question
to enforce, improve notifications for abutters?
Very good.
Is really what I was hoping for. So,
All right, Jay.
thank you so much.
All right, I'm going to be surprised if there aren't any other questions, so. Come up, Scott.
Gary, Nick,
Hi, Scott.
got a couple comments and I got a couple suggestions I'd like to share. I don't think you're gonna be able to particularly give me an answer for this, but trouble I've had over the years of filing applications with the Conservation Commission is that the way the ordinance is written, there's a lot of ambiguity to it. There's a lot of not a definitive structure in it as far as how to proceed or how to address things in particular.
And Scott, you're talking specifically about the local wetlands protection ordinance, not the,
Yeah.
Okay.
I am.
as opposed to the wetlands protection. I just want to make sure I'm clear. Okay.
Years ago, I filed an application for a notice of intent for a client that wanted to build a house on Lindsay Street. And we had cited the house 4 feet, house corner was 4 feet off of the 25-foot wetland protection zone. We were outside of the wetland protection zone. We had no unusual grading. We were pretty much at grade. We had a walkout basement. And the question came up from the commission. They said, what if an applicant put a ladder up against the corner of the house? Where would the rungs of the ladder be? And I said, well, I would assume they'd be in the wetland protection zone. They'd be more than 4 feet off the house, or the fellow would fall backwards. They made me move the house till it was 11 feet off the 25-foot wetland protection zone. Now, that's an extreme, and it doesn't happen that often, but my point is, when you have a different commission, a different sitting commission, you get some pretty wild interpretations of how the regulations are applied. I'll give you another one. Wasn't that long ago, I filed an application for notice of intent for a house on Park Street over by the liquor store. I'm sorry, the address escapes me, but I can't remember where it is, but I think most people recognize it when they go by. The majority of the upland of that property was in the rear of the property. And let me back up a second. Whenever I've ever come in and discussed with you or a previous agent, I've always talked about the way that the wetland protection zone is treated as a no-touch. But I'm always assured that it's not specifically a no-touch. There are situations where you can be allowed to make a disturbance within it. The piece on Park Street had a very large upland that could support a single-family home, driveway, garage, shed, everything just fine. We had a pinch point to access the site. The site had 50 feet of lot width at the street. Going back on the right-hand side, there was a fence, and we had a pinch point to bring that driveway around between that fence post and the 25-foot wetland protection zone. We proposed to encroach into that wetland protection zone 6 feet with just a portion of that driveway just going around the corner. Made perfect sense to do it. It was a perfectly good argument to access the upland there and put a house where it ought to be on that lot. Well, we were denied. We received a denial from the Conservation Commission because they did not want us to touch the wetland protection zone. We redesigned the site. We designed it so that instead of having a driveway going to the back of the property with a house with a garage, we put a parking area in the front on the 50 feet of frontage, the front portion of the lot. And we had a walkway so they could park out front and walk to the back of the house. It was denied by the commission. We filed for a superseding order of conditions with DEP. We had a site visit. The commission was present. And one of the commission members said, when they looked at the wetland, the quality of the wetland and the quality of the vegetation, everything there, one of them made a comment, this is what we're trying to protect. But nonetheless, my point is, DEP did finally issue a superseding order of conditions allowing us to put that house in the rear of the property.
Scott, my recollection was the appeal was filed by the abutter, because they had hired that attorney who put together that appeal letter
But the Concom still denied it.
the first time
All right.
with the driveway.
Okay.
But my recollection was, and I will pull the file tomorrow because I want to make sure that the
Well,
truth is actually
that's my
there.
recollection. I'm old, so I
Yeah.
have an excuse.
No, I don't, my recollection is the first one was denied. I agree with you there.
But I'm
the
saying,
second
it was
one
the perfect
approved.
opportunity to allow a disturbance that was permanent,
Mhm.
but had extremely little impact, if any,
Yeah.
on the wetland itself.
Mhm.
Okay. The other thing I want to talk about is the, in this draft for the new revisions to the ordinance, it talks about deleting language within the old ordinance, replacing things with lands within 25 feet of the resource area and the 20-foot wide continuous and undisturbed wetland protection zone. All these things that say 25 in the current ordinance are going to be replaced with 50.
Mhm.
And it also says here, it says, in inserting in place thereof land within 50 feet of a resource area and 50 feet in a 50-foot wide continuous and undisturbed wetland protection zone. That says it's undisturbed. It doesn't say there's any opportunity the way that is written. Now, that's just a suggestion. I'm just saying it's a little confusing.
Well, and that's the distinction between the ordinance and then there's the regulations. But just not far below that section where you have currently it's A, B, and C, it talks about some of the activities where the commission may allow.
Yes.
And one of those was the access portion.
Yes, it does, but depending on where you read it within the ordinance, I'm just saying it's a little confusing.
Oh, I know.
To me. On the third page, under exemptions,
Scott, could I just ask you, could you cite what section that's under, if you don't mind, please? The application of the word
Section-
undisturbed?
section 18-1.8 permits and conditions.
Okay.
Under 18-1.8.1 exemptions, each exemption here, a majority of them talk about, and further provided that any work within 25 feet to a nearest wetland resource area shall still require an order of conditions and any other relief required hereunder. Any work within generally 50 feet is going to require an order of conditions anyway. This is an order of conditions specific to the local wetland ordinance.
No, that's referring to an order of conditions in the Wetlands Protection Act, and I agree there should be some additional clarification there.
Okay, you understand what I'm
Absolutely,
saying?
yeah.
Something I've never understood for years is that the property can be affected by a 100-year flood elevation. Floodwaters can creep over 100 feet easily into a flatter property. And the Conservation Commission has applied a 25-foot wetland protection zone to
The floodplain line.
a limit of a 100-year flood that happens on the occurrence of approximately once every 100 years. It seems, I don't understand what the protection is to a piece of land that floods in a 100-year storm, which we may have never seen. Why you have a 25-foot protection, now want to have a 50-foot protection to that, because that prohibits people from that have floodplain coming into their property. That additional 50 feet could really significantly affect a piece of land. But any major flooding I've ever seen downtown or anywhere else, it's a matter of hours before that water recedes. What protection are we trying to give the floodplain on that occurrence is my point.
So really, that is trying to factor in future floodplain, because the floodplain is not something that is static in perpetuity. As we get better rainfall data, and we have rainfall projections, every now and then FEMA updates those maps. Great example is we have new maps that were just delivered to us by FEMA that will change the 100-year floodplain in various areas throughout the city, and those go into effect of June of this year. So there are cases where having that wetland protection zone exist for the floodplain may account for that future floodplain. Now, there's been plenty of cases where people have filed applications with the commission, and we review what's going on in there. So on a case-by-case basis, Scott, we're going to look at its relation to whatever river or stream that floodplain is coming off of, and see, are you proposing a structure that could potentially harm the flow of future floodwater or things like that. But there is that section in 1.8 of the permits and conditions that you were reading from before. It's subsection C, which talks about how the commission may allow alterations within that floodplain, especially within previously developed areas.
But I'm saying if you had a bare lot and the floodplain was identified by survey, by elevation, if that was a determined elevation, you're going to be adding now a 50-foot buffer to that. What does the buffer protect? I mean, as people develop property in the future, now or in the future, FEMA maps are eventually updated.
Yeah.
And they would deal with the updated numbers as they come. That would move that line, one way or the other, however it happens to be. But why take 25 or 50 feet of someone's land? That whole thing could be 150 feet of lawn that they use, and they just want to keep it at that.
Yeah.
However, if they do something on the property, if they make an improvement on the property and have to file with the commission, either it's with a request for determination with a notice of intent, that line has to be flagged because it's a resource area under your ordinance, as wetlands do. And when it's all said and done, when someone tries to permit something within the 100-foot buffer, say it's outside of the wetland protection zone, you require the construction of a fence. So now the
That's a
fence,
temporary
instead of the
construction.
fence being 25 feet off a
Oh, you're talking
100-year
about the split
flood,
rail
the fence is gonna be 50 feet off the 100-year flood. That fence is gonna go run across the whole property, parallel with that line. It's gonna have placards on it saying it's a protected area, or, area, conservation area, whatever. And you deny access to that perhaps 150 feet of property that they can't use. You're fencing them out. I don't understand, it has nothing to do with water quality or anything. It's on the occurrence of once every 100 years. Why penalize people's property or possible development of the property by taking that land away?
So that's where we're going to revert to the interest of flood control. But the way the ordinance is written now, and the way it would still be, is that there's the presumption of significance, and that presumption may be overcome. So if you're telling me through an application that we have evidence to show that even in a 500-year storm event, it's not going to come up into that wetland protection zone, then that could be a way that you overcome the presumption of significance and allowed to develop within that.
Well, if I wasn't there, I wouldn't even file. If I know where the 100-year flood limit is by survey, which is really the only way to do it if you have an established grade, or you're gonna do an inflow analysis of the property to determine where it does come up to, that's a known commodity. I still understand the protection you're trying to offer. It's not a vegetated buffer. It's not a bordering vegetated wetland. It's not a pond. It's not a river. It's a temporary influx of water that lasts just for a period of hours. Why protect it with why penalize people with the setback for the buffer zone, the wetland protection zone?
We regulate not only, wetlands themselves, but the flood zone, because they are a shared resource. They extend beyond property lines, they extend beyond county, state, and all that. Part of the reason they are regulated and required to do a review under the Conservation Commission is to try and ensure, in addition to protecting the wetland resource areas themselves, when it comes in terms of flooding, we're trying to make sure that that's not going to exacerbate impacts on someone's poor neighbor when they're doing some of these projects. So that is the purpose of doing the review.
But we're not, if we're outside of the flood zone, we're not taking up flood storage, right?
Correct.
Correct.
So the 25 to 50 feet isn't gonna make a difference.
Depends
It's not
on-
gonna offer any flood protection for anybody by keeping someone 50 feet away from a 100-year flood elevation.
So Scott, what essentially, we could discuss this, I'm not trying to cut off the discussion.
Yeah.
Your question is, would the city reconsider that buffer off the floodplain line, is your question?
Yes, I think in certain instances, it's extremely unfair
Okay.
to a landowner,
Sure.
especially if you're gonna do something new on a property. We just cited a house in South Attleboro on a plan. We had the surveys mark the 100-year flood. We put the 25-foot wetland protection zone on it, and we had to create a very unnatural house placement on the lot just to get it out of the wetland protection zone. And it seems kind of foolish because again, it's something that if I had that extra 25 feet, could have been a normal looking home. So.
But this is where I refer back to under the regulations, section 4.9, where it talks about the wetlands protection zone, and below that, where it talks about the different forms of disturbance. It could potentially be a form of permanent disturbance that may be allowed by the commission. But again, it's a site-by-site basis, depends on the scope of work, the activity that's being proposed, and if the commission believes that would that permanent disturbance potentially result in cumulative adverse impacts. It's not saying that you can't do that or whatever project you want to do at all, but there needs to be a review process to ensure we're not harming the interest protected under the ordinance.
But I think the long and short of it is, he's asking if we would go back and consider whether or not we need to have that. So I don't think you're debating the merit of what Nick is saying, that it's discretionary. I think you're saying, I get it, but why even leave it to discretion? Could you please consider not having, whether it's 25 or 50 feet off a floodplain line, is your question,
I think the
right?
reason for having a wetland protection zone abutting a resource area, a wetland resource area, such as a bordered vegetated wetland, pond, stream, river, whatever, is understood. But when you take something that floods like I say, on a rare occurrence for very little time, it doesn't seem to apply, it doesn't seem correct to apply that protection
Sure.
to that.
And as I say this, please, I'm not just making this a platitude, I mean it. Again, your question is, would we go back and reconsider the application of that buffer off the floodplain elevation, whether it's established on a FEMA map or calculated in the field? Yes. All right, sir.
And just to concur with Gary, yeah, it's certainly worthy of consideration.
Reconsideration, yeah.
Reconsideration to look at land subject to flooding
Yep.
and how we apply a wetland protection zone and what, should that get the same wetland protection zone that wetlands and waterways do?
In isolated land subject to flooding, there's no minimum on that either, right?
What do you mean a minimum? Like the threshold to be declared?
Yeah.
We can refer to the ordinance and I'll tell you. So it needs to be
Under the current ordinance.
under the current ordinance. So we're not proposing to change that threshold as far as like what it needs to be declared as isolated land subject to flooding.
Right. You apply a 25-foot wetland protection zone to that,
Currently, yes.
all right? But I'm saying it doesn't have to be quarter acre foot or anything like that, right? That's a different, that's a state regulation, not yours.
So the way it is right now is that, so these areas include any isolated shallow or special flood hazard area or closed basin, which at least once per year can find standing water characterized by ponding or sheet flow to an average depth of at least 6 inches, and a surface area of at least 2,000 square feet, or an equivalent volume of 1,000 cubic feet.
It's a very small area.
Yeah, so that's how that's defined currently.
All right, last thing, promise. If I was a homeowner, had an existing house, I want to put an addition on the back, my addition's going to encroach into the 50-foot wetland protection zone, but it's currently a lawn. There's an exemption for that right now.
Yes.
I still have to file, I still have to prepare the applications, I still have to have my wetlands flagged, right? I'm still going to be subject to putting up a fence at the 50-foot setback.
For an addition?
Once I, if you change the wording in the current regulation to take out 25 and put 50 in, says at 25 feet, I have to put a post and rail fence in with the placards on it. So if I have a house that's sticking out into the 50-foot buffer, the 50-foot wetland protection zone, am I gonna have to bring a fence up on either side of that house until it hits the house?
In the vast majority of cases where we have additions onto existing property, the commission has not required a split rail fence with conservation placards to be put on there. That's typically a special condition applied to new construction. And that is how I recommend when it comes to, if they are approving an order of conditions, I recommend that the split rail fence only apply to new construction.
Then I would suggest you make that a little clearer in the regulations, because it doesn't say that right now.
I wouldn't want the regulations to specifically call out a split rail fence, because conceivably, if the person who is going to be living in that home is intimately involved with the actual application process, they may have a different suggestion for a fence. One of the reasons why we do the split rail fence is because it doesn't pose a significant barrier to wildlife movement, and it's a relatively inexpensive fence to install. So I wouldn't want that super specific in here, because someone maybe they want chain link. There could be some other type of fence they want. So we still want to be able to provide flexibility in that sense.
I just think you should make that clearer in the revised ordinance if it gets to that point.
But there's nothing in the current ordinance that says like, oh, the commission's going to require a fence. That's just become standard policy.
You've made us put up a fence on every project we've ever done.
Well, what I'm saying is,
25-foot buffer.
in the vast majority of cases, yes. If it's new construction, yes.
But this is a different,
I
this is a
agree.
different circumstance. And now you have a house that can protrude into the wetland protection zone. You don't have a house projecting into 25. So I'm just saying it should be clearer that it cannot be interpreted by a current sitting commission that might say, they just want to bust someone's buns, they don't like them. Hey, you got to put up a fence at 50 feet. Sorry, that's what the regulations say.
But there are cases where, again, I would not advocate to have some type of specific provision in, whether it's the ordinance or the regulations portion, that says you have to do this fence every time, because certain sites aren't going to warrant a fence. Like if you have a site where there's a big piece of ledge that's 10 feet tall, that's just consider the hypothetical, like 10 feet tall, right at your wetland protection zone. I mean, you have a big immovable barrier there already. So, if that happens to be within the wetland protection zone, it doesn't seem practical to require the fence there. And Scott, there's been plenty of cases where, depending on what's there for vegetation, we may require, instead of a fence, wooden posts with our placards. Because we've had certain properties where if it's a larger property, they have a large tract of forested land, they may have already trails in there. We don't want to prevent the access to those trails. We want to encourage passive recreation. So that's an example of, there's been cases where instead of a split rail fence, we just say, okay, put up some of the 4x4 posts with the conservation placards. So that way, we're still having our wetland protection zone delineated, but we're not putting as much of a barrier for them to have passive recreation there.
I just wouldn't want to have a fence or a row of posts in my backyard, something I could still theoretically mow. And just have to mow around them and just have that eyesore there. That's just me, but I think it warrants
Yeah.
a different consideration, that's all.
Yeah.
Thank you.
Scott, you understand the whole purpose of the fences though, right?
Excuse me?
You understand the whole purpose of the fence, right?
Well,
Because the purpose of the fence is to alert property owners that there is a regulated resource area there. Because one of the things I have heard time and time again in my position as the city's conservation agent now is no one told me there were wetlands here. And it's not a good part of the job when I have to go to all these homeowners and unfortunately be the guy that tells them that they committed a violation of the Wetlands Protection Act or the local wetland ordinance. The fence with the placards at least provides something that's there, so when they're about to purchase a property, they can see those and go, okay,
What's this for?
what's this for? I can look at the placards and go, okay, that's a regulated resource area. And then it says Attleboro Conservation Commission on there. We reference our Wetland Protection Ordinance 18-1, so they can get a little reference on what this truly means. So it's designed to try to
Alert them.
alert the property owner that, yes, there is a regulated area here. Because the vast majority of the time, real estate agents don't say anything about it. And one of the lines I've heard the most in my career is, my real estate agent said this, and then you can fill in the blank after that. So we do that split rail fence where I understand not everyone loves the aesthetics of it, but if it can help prevent violations, that's the whole purpose.
but it also prohibits people from accessing their property. You allow passive use of the 25-foot wetland, vegetated buffer, wetland protection zone,
Yep.
as long as they can jump a fence.
So this is where we can work with people.
Yeah,
If they wanted to
openings,
take
so-
out a portion of the fence just so they could use it passively,
Then there should be something, see, this is, again, this is where I'm going with the interpretation thing. If it's not written that way, it doesn't have to be interpreted that way.
So again, so I'm taking these notes, so aside from, I'm trying to capture all your thoughts, Scott. So what I'm hearing you say too, is whether you agree or not, the question is if we have to live with a split rail fence, can you at least provide a gap in there so that people can still understand that they can still go and enjoy their property? Whether or not it's taking out a couple of split rail fences, so you have what's the distance, 8 feet, 10 feet? Or we require the Concom, in instances of when it requires a split rail fence, just allow for a 5-foot gap sporadically in the backyard so, they don't have to hop a fence. If that's your request, that's a reasonable request, okay.
Thank you,
that's a very reasonable request.
thank you.
Mr. Salone?
Oh, sorry.
Yeah, he had his hand up for a while.
Ken Salome, and I'm from Attleboro. And the question is simple. What determined the 25 feet? How'd you come up with that number, the additional 25 feet?
I was quite young back then and not in this position.
So,
No. I'm talking about the proposed changes that were the additional 25 feet.
Oh, so the 50 feet.
Yeah, the 50 foot, right.
Yeah. Reading various research articles talking about vegetated wetland buffers. Most of them talk about generally less than 50 feet is ineffective at least filtering pollutants. Now, if you're talking about wildlife habitat buffers, those generally need to be much larger. Now, I don't think I would really get very far with the city council if I said we needed a 200-foot buffer applied to every wetland. I might get run out of town if I do that.
There was an earlier, I think it was a projected proposal for 75 feet. And
Yes.
do you know why we're
yeah,
reducing that?
so we're gonna go back in history a little bit.
Okay.
So when this was originally proposed back in the day before the city of Attleboro adopted the stormwater ordinance, and we did so because of the NIPD's permit, which is a federal mandate. if I recall vividly, and I was part of the crafting that language back in the day, I think we started off with 100, and there was some segment of the public said, well, we're willing to go with 10 feet. And I vividly recall that night of the public hearing, I said to the council president, I'm standing where you are. So that's about the distance between where you're sitting. I think it was Madam President at the time and myself. I said, let's put this in perspective. 10 feet really doesn't accomplish anything. So why even do it just to give lip service, just because we could say Attleboro is a 10-foot buffer when it accomplishes nothing? So I recall it started at 100. It got diluted down to 10. And then, I'm gonna be quite honest with you, it came out to be, we advocated for more than 25 feet. It could have been 50 or 75. But ultimately, the wisdom at the time was, well, let's settle for a compromise and establish a 25-foot buffer. The Conservation Commission at the time had no buffer. So whether begrudgingly, willingly, unwillingly, it embraced a 25-foot buffer at the time. I think under the previous administration, the proposal was going to extend it out to 75 feet. Then ultimately got brought back down to 50 feet. Look, Nick and I are going to argue that even 50 feet doesn't necessarily address or meet the standard of what we're trying to achieve. But again, out of the spirit of cooperation, and times have changed. That ordinance was adopted almost 25 years ago. So many rules and regulations, environmental regulations, they don't retract, they get more restrictive. So if this was 2 years later, 3 years later, come on, Gary, we haven't even had time to get any traction to understand the implications of a 25. It's been a quarter of a century. It's been sitting out there for a while. So at this point, again, to have a better protection, to address all of the three components that Nick mentioned about flood storage and water quality, and I don't have to go enhance protection of the wetlands. He and I agree, it's 50 feet doesn't really do, but it's better than 25 feet. So it evolved, Mr. Salom. So honestly, it was 75 or 100. I think 100 when we started. On the table was 10 feet. The council repudiated that, which was fantastic. Ultimately, the compromise was 25 feet. And we've lived with that for 25 years. Times have changed dramatically since that time. More development, more runoff. So we decided we need to improve that for everyone's, again, of course, we're going to argue, how do you measure that? Well, it's a quality of life measure. And all scientific studies point to that. 50 feet doesn't do it, but we're not going to come in and, as Nick said, increase that to 150 feet to 200 feet, because that's not practical. So we respectfully think, humbly, that 50 feet is now the standard we should move forward with. And let's go back and maybe 10, 20 years from now, recalibrate to see what that's doing. And that's how we derived the 25 feet to where we are with 50 feet.
I guess my point is the additional 25 feet enough? Are we, looking towards the future, or are we just accommodating the past?
So I would say when it comes to wetland buffers, it's going to be site-specific. Certain wetland areas are going to have different needs, but if you're going to make the regulations extremely complicated if you have such variable buffers throughout. And it's going to make property owners very angry when they're trying to plan a potential development when there is so much nuance. So this is why we go with just
A standard
wetland protection zone, 25 currently, proposing the 50. That way it's much easier for current landowners and prospective landowners to plan around.
And in as much as the commission would be judicious that if you gave them the latitude to pick and choose what the distance should be, again, as Nick said, depending on the quality of the wetland, in this case 35 feet, in this case 45 feet, in this case maybe 100 feet. It's not fair to the engineers and the property owners who need to design something. So you can't really walk into a situation where you're just rolling the dice and assuming I'm going to get a 40-foot when the commission turns around and says you need to double it, or come in and impose 80 feet when maybe the quality of the wetland doesn't warrant it. And Nick has mentioned that, and there are times it doesn't warrant it. I think we heard Mr. Ralph say there are times when the commission members have said, is that what we're protecting? So out of fairness to everyone, so there's some level of continuity, a standard we can all agree on, is that's how we apply 50 feet. What, does that apply in all the, it probably doesn't. But it's something we could all agree on, and that's the standard we're gonna jump off today, and we'll revisit that 15 years from now or so.
Well, I also hope the homeowners understand that it's actually protecting them. You know, I mean, I know it might be violating their, you know, personal property rights in some instances. It may be, you know, the perception, but it is actually protecting them. Okay, thank you.
Yes, sir, right here at the front.
Hello, Matthew Pearson, Lindsay Street. I was looking at some of the exemptions here, and I know a lot of the new constructions in the past 10 years or so have had underground propane tanks, and I see that that's missing here. I was just wondering, is that something that maybe could be added, or is that like a special case?
Underground propane tanks. I mean, we could certainly consider adding it,
So regulation of propane tanks within the buffer.
as in like an allowable activity, or?
They have to be replaced every 30, 40 years, I think.
Certainly consider. I'd like to think about it. I mean, ultimately, it'd be up to the city council, but I'd like to run it by the Conservation Commission to see what they think about that.
So, but what's the question? I guess I'm not,
I guess, would you want it to be an exemption? Is that? what
Yes.
you're getting? Yeah, okay.
okay.
I mean, I think certainly if one's already existing,
Yeah, I think so.
and you know, need to replace it, I would generally, I think I would be okay with an exemption if it's already pre-existing.
An existing one, yeah.
Yeah, if it's pre-existing, you know,
Kind of similar to
if like the
septic
entire
tank.
city council were to ask me right now, I would say I would like to have a provision in there that says, provided there's no feasible way to move it further away from the wetland, just because any petroleum products being near the wetland and whatnot, I prefer if we can get them as far away as possible. Now, I understand that's gonna be really specific on how your house is designed and cost, of course, of new installation or things like that.
But if
It-
it's
it-
pre-existing, you would think that it would be exempt under the exemptions that we have.
Yeah.
So, but absolutely. So
yeah.
we will consider that as a modification.
Yeah, I definitely, I'd like to talk about it more. If you got some suggestions you want to run by me about what that language may look like, I'm certainly happy to entertain that.
Well, it's, so there's like repairing or replacing an existing septic system. I would just replace that with underground tank.
And
propane.
underground
Maybe
storage.
you can, if you want to make it specific to propane, so it's not oil
Yeah.
or something.
Yeah, like I'd like to talk to like maybe our fire department, get their input on that, and just see what they think about, because I know that typically they regulate a lot of the underground storage things.
My guess is it probably has to be a certain distance away from the dwelling as well.
Yeah, that's where, you know, like we're all saying, oh, is there any way to locate it? Like, I don't want to like conflict with like maybe other regulations that you have to contend with. You know, I don't want to make it too convoluted. Yes, definitely worthy of consideration. I'd like to think about it a little more and then see what some proposed language could look like. Because again, for the vast majority of maintenance projects, we do want to make sure that, you know, you're not having to file an application for everything that's conceivably out there, but that's not something I had originally thought of. So thank you for bringing it up.
Thank you.
Any other questions? Yes, sir. John, you're next, okay? There.
I just had a question about the exemptions. So I think you guys said if it's existing disturbed land, it doesn't have to go in front of the commission. Is that true? Did I misunderstand that?
So for which, are you talking about like an addition or?
Or like, so I have a patio that I want to convert to a 4-season room. That doesn't need to go in front of the commission because it's already disturbed. It's going to maintain the same footprint.
Yeah, so we consider it an addition. So as long as it was more than 25 feet away, then it would qualify under that exemption.
Okay.
Yep. You may just need to file under the Wetlands Protection Act. But that's one of those things where you can email me a copy of your plan. And then I can always, you know, schedule a meeting with you to look at the work area, and I can give you my professional opinion on, is this something that truly qualifies as an alteration requiring an application under the act, or does it not, and you can just go for a building permit?
But for purposes of the local wetlands protection ordinance, going from 25 to 50, it would not. What Nick is saying, just to make clear, is if it does require an application, it's because of the Wetlands Protection Act, okay, not the local ordinance. So if it was clearly the local ordinance, you would be exempt.
Okay.
Okay, sir?
Thank you.
John?
As it relates to the, to the drinking water, right? The surface water areas that we derive our drinking water from are in Zone A, right?
Yes.
And could you tell everyone what the buffers are around those resource areas?
So buffer for Zone A drinking water resource areas as defined by the state is 200 feet?
That's 400 feet.
Those 200.
All right,
It's 400 feet from
It is 400,
my
okay.
research.
I think it's 400 feet.
So
Is that
does-
what you said?
Yes, it's
Yeah, I
four-
think it's
it's
400. Yeah, that's what I
400.
said. I think it's
And so
400.
now, does this add an additional 50 feet to that because it is a resource area? Or,
No, so our ordinance does not regulate the Zone As. So we only regulate the wetland resource areas themselves. So like another example too I want to provide is Wetlands Protection Act regulates riverfront area. Our wetland protection zone is not on top of the riverfront area. It would only apply to the bank of said river and extend out from there. So,
okay,
yeah, so no, it would not apply to.
so it's 200, it's not 225 at that
Correct.
point?
Yeah,
But the vernal pool gets 125?
correct.
Why that variation? Because it's not protected under
That's
the
right, under the
Wetlands Protection Act?
Act, it's not, but it is, whether it's a certified vernal pool, and correct me if I'm wrong, Nick,
Mm-hmm.
or a potential vernal pool, those are specifically regulated by the local Wetlands Protection Act, whereas they are not by the Wetlands Protection Act, the state,
Yeah.
chapter 131.
Yeah, because Wetlands Protection Act, in order for it to be truly regulated under the act as a vernal pool, it has to be certified by the Natural Heritage Endangered Species Program. But the act really limits that protection. So even if it gets certified, okay, they say, yep, there's 100 feet of now protected area off of that vernal pool, but it's only if that's within a bordering vegetated wetland. So conceivably, I mean, there's vernal pools out there that are really just on their own without any wetland surrounding them. They're surrounded by upland. So if it's a certified vernal pool by the state, there is no other protection outside of the mean annual high water line. So if it wasn't for our local ordinance, you'd be able to build
Right up.
right next to the vernal pool, which would have, over time, is going to have significant cumulative adverse impacts, because if you're taking down the tree canopy that's next to it, the vernal pool may dry up. You may have other issues where, especially if you have a lawn that's being fertilized, you're gonna cause, potential nutrient loading that could acidify the water. So that's where, when it comes to vernal pool protection, a local wetland ordinance like ours is critical in truly maintaining the natural order around the vernal pool.
Okay. Just two follow-ups, I'll try to be quick. Are there any actions that the city is taking on its own to handle untreated stormwater? Because, I mean, there's 200 miles of roadway throughout the city, and most of the stormwater deposits directly right into wetlands.
Yes.
And so, as from a person who's involved in new construction, I know that all of our water is handled, held, treated.
Yep.
And so whatever's discharged into the wetland is filtered.
Yeah.
And so, shouldn't we share the burden here, or shouldn't there be a pathway to ensuring that those waters get clean?
This is a great question, John, and I am very happy you brought it up. So is the city responsible for, maintaining, managing stormwater and treating it and also making improvements? 100% yes. So the city is subject to what's called our NIPDES MS4 permit. So NIPDES is an acronym standing for the National Pollutant Discharge Elimination System. That is a program that is born out of the Federal Clean Water Act. And then the MS4 is our Municipal Small Separate Sewer System. So fortunately in Attleboro, we do not have combined sewer and stormwater system. Your sanitary sewer and our stormwater drains are entirely separate. We are required to submit annual reports to the EPA each year. So I, as the city's environmental planner, I serve as the city's MS4 program manager. We are required to do testing of every stormwater outfall that we own in the city. We test those for a variety of pollutants, such as nitrogen, phosphorus, fecal coliform, E. coli, ammonia, and then anything else that could potentially be a pollutant or contaminant. And we look for illicit discharges. If we get a hit above reportable thresholds, whether that's from DEP or EPA, our job is to then trace that through the system. So in my tenure here, I have been working with a team of stormwater consultants to go through every stormwater catchment in the city, starting with our most high problem outfalls. How do we determine the high problem outfalls? Looking at a combination of where we've seen high chance of pollutants, so highly developed areas, but also looking at impaired waterways, which would include the 10 Mile River. 10 Mile River is subject to out-of-state total maximum daily load, also known as a TMDL. So I say out-of-state because Rhode Island has developed standards for the threshold of pollutants that may be allowed to enter it in a given year. Mass DEP has not given us our own dedicated total maximum daily load for the 10 Mile River, so until that happens, we're subject to the out-of-state Rhode Island standards. So as we trace through the catchment system, trying to find the source of pollutants, there's a variety of ways we do that. Combination of putting sandbags at every junction point, waiting 24 hours, coming back, taking a new water sample, seeing, okay, did we get a hit on the pollution here? If we did, we keep going through the system. If we do not, we go back to where we just had it. Okay, so that's how we narrow it down. Put cameras into the lines. You check to see if there's any laterals coming in there that aren't mapped. And then generally, if you have a lateral that's now coming out to an old place of business, it's a pretty good idea you have an illicit discharge and that's where it's coming from. To further confirm that, we request dye testing in buildings. They put the dye in there, it comes out, we see it, we confirm the illicit discharge. And then the stormwater ordinance has provisions in it where it allows me to take immediate action requiring removal of the illicit discharge. In addition to that, the NIPD's permit requires us to identify various public properties that are suitable for retrofitting of the stormwater system. One of the bigger ones that we did was the water treatment plant out at 1296 West Street. A variety of GSI infrastructure, so green stormwater infrastructure. And what I mean by that is bioretention areas, infiltration basins. So your standard stormwater management system in the city of Attleboro is what we call gray infrastructure. You have your catch basins, which are the storm drains in the side of the street, collecting the water. It puts it into a pipe, and generally how they did everything prior to all these standards we have is it got put into a pipe and then it got dumped into the nearest low point or water source. And anywhere around the downtown, all of it's going into the Mile River one way or the other. With the stormwater ordinance, any new development, redevelopment, they have a variety of standards. First, you have to try and infiltrate the first inch of runoff from a storm event on your property. So trying to keep rain exactly where it is falling rather than just shoving it downstream for the next guy to deal with. Next is water quality. So, not only handling the volume of water in your property, but addressing the water quality concerns. You need to take out what's called TSS, which stands for total suspended solids. So anytime, especially if you've been around any construction sites in a rainstorm, you see a lot of that dirty, murky water, that's what we're talking about TSS in there. So when post-construction is complete, you need to have proper stormwater management systems with pre-treatment that require the removal of all that TSS. Current standards for new development under the Attleboro Stormwater Ordinance is 90%. Additionally, we updated our ordinance in the November of 2024. We now require definitive total phosphorus standards. So for new development, we're requiring removal of 60% of your total phosphorus that's in your stormwater. That's done to improve water quality within our wetlands and waterways as well. Helps cut down on algae blooms, acidification, things like that. Moreover, the other things we're doing right now is I am in the midst of finishing up a green stormwater infrastructure project under the state's Executive Office and Energy Environmental Affairs Office through their Municipal Vulnerability Preparedness Program. We did a GSI feasibility study for in and around the downtown area, really focusing on North Main Street, South Main Street, Thatcher Street, Park Street, or at least a small portion of Park Street, and County Street. With that, we have a whole set of concept plans for various green stormwater infrastructure that can be retrofitted into the existing gray stormwater infrastructure. The intent would be to not only improve water quality of the 10 Mile River by providing better pre-treatment, but also improving the infiltration so we can help recharge groundwater, but also reduce the volume of water going into 10 Mile River. Hopefully reduce some of those flooding impacts we see, especially along County Street where the County Street Bridge goes over the 10 Mile River. I know we've all seen the jewelry outlet and Tex Berry's and the nail salon over there underwater at least once in our lifetime here if you've lived here at least 10 years or more. So that's a project we're doing there. And I am hosting a public meeting on that as well. April 4th, Saturday, April 4th at
10:30.
10:30 at the library. If anyone wants to see those concept plans, we welcome your comments on that. Trying to make sure that the public is aware of that project, knows what's going on. We want feedback. So those are just a couple examples of.
So you're doing your part, so we
Yeah, we
appreciate
think we
it.
are.
It's a collaborative effort. This is when it comes to stormwater and especially, dealing with flooding, it's not a single entity's problem. It's everyone's problem. So, the city, we're putting our best foot forward, trying to do a variety of different things, so not just stormwater, but local wetland ordinance.
Terrific. This last part of it might be a little prickly here. If you let me, just give me one second here to ask this specific question, because for me, this is the meat and potatoes of it all. Is the purpose of the expanded WPZ to ensure that when the commission issues a decision, or when the commission issues a denial, that it is final? All right, and when I mean, if it's a negative determination and it's final, and now the applicant will have no expedient way to appeal with the Department of Environmental Protection. So I just said a mouthful there, but under the Wetlands Protection Act, any work that seeks either an order of conditions or a determination of applicability, and if the commission renders a negative determination,
It's appealed to DEP.
it can be appealed to DEP, correct? Right, and so the adjudicatory process is between DEP, the city, and the applicant, right? And so, with all due respect, the commission is made with, not to say that you're all not experts, but generally laymen, people just doing the job for the city, and DEP are scientists, biologists, people who are experts, looking at the merits of that decision and then determining, is this going to be a negative impact to the resource area, or did maybe the commission overstep and was a little too heavy-handed? And so within 60 days or so, there's a possibility of a superseding order of conditions could be given, and now the applicant is free to proceed in construct the project as they so desire. Now, with whether it's the 25 or the 50, if the commission issues a denial or a negative determination, could you explain how the applicant, if they feel that they were mistreated or given the wrong decision, what is their avenue to seek justice?
They file an appeal to Superior Court.
You would need to file an appeal with Superior Court. For the
You would
decision
have
on
to
the local
file
ordinance, yes.
to Superior Court, right? And so effectively, you're taking something that could be decided by experts in 60 days, and you're now putting it into the hands of a Superior Court judge who's not going to look at the merits of whether or not there's negative environmental impact. They're really only going to look at the ordinance and whether the city created the ordinance properly. I don't know how that's fair. I know it gives the commission more bite and more teeth to say, you know what, no, our word is final, that's it. We said, no, you can't do anything in that 50 feet. Good luck in Superior Court, 3 years getting a court date and thousands, tens of thousands, 20s of thousands of dollars trying to overturn it.
So can I jump in?
Sure.
So that's a more fundamental question, whether it's 25 feet, 50 feet, or 25 feet plus X. You're actually getting to the core of having the local ordinance.
Yes.
Okay. If that's a question, that's a bigger question. You're talking about the validity of that and whether or not it is fair to have a local ordinance.
Yes.
That would conceivably, if a conservation commission were to deny a permit, that you don't go to DEP, that you would go conceivably to Superior Court.
Yes.
Maybe to Land Court. It's tantamount to any decision of a planning board or a zoning board, and I won't go off on a digression, but any of those decisions go to Superior Court or to Land Court. We are in no position to judge a judge's qualifications on how he or she would adjudicate that. So So any decision by a local ordinance, whether Concom, planning board, or zoning board, under the subdivision regs, the zoning ordinance, or the local wetlands protection ordinance, or under the local stormwater ordinance, that's the way the process is set up, is that you go to Superior Court. The Conservation Commission, let me back up. The Municipal Council, when it adopted the local wetlands protection ordinance, did not make a conscious decision to say, okay, well, unlike the WP, unlike the Wetlands Protection Ordinance, where you can go to DEP, now we're gonna make it so you go to Superior Court. That has nothing to do with DEP. That is a local process under the general laws of the Commonwealth, where an appeal of that decision goes pretty much to Superior Court. If you're gonna question that, I don't think Nick and I are in a position to debate that, because, and I'm not arguing, it's a valid point, but that's a legal issue that we need to discuss further. But that does not invalidate whether or not 25 or 50. That's what we wanted to advocate for tonight. You asked a valid question. Why does a denied permit application under the Local Wetlands Protection Act, why is it fair to have to go to Superior Court and conceivably argue a case before a system whereby, in your humble opinion, there aren't qualifications, whereas under the Local Wetlands Protection Act, I can go to DEP and talk with someone who speaks my language. I get it.
Yeah.
But that isn't anything that we can control over. That's the way the system is set up. So again, if we want to have that debate, we can.
Well, you
but that's
control
a
it by.
I'm sorry.
I'm sorry.
Yeah.
You control it by imposing the ordinance, right? Because
What do you mean?
if there was no ordinance, if there was no 25, if there was no 50,
Right.
right, we would be under the Wetlands Protection Act, and we could file to DEP and seek a superseding order. And at that point, it's me against you.
Sure.
And, let the best
Yeah.
man win.
So the quickest way to that, look, just how, as any ordinance can be amended,
Yeah.
any ordinance can be repealed. So I would suggest, again, valid point, you're debating some level of unfairness that anyone spends X amount of dollars, goes before a commission, and the commission, in its infinite wisdom as it applies the rules and regulations in the ordinance, opines that you don't deserve a permit because there's something mechanically wrong, and even though, and you know this out of fairness, the commission never just says no out of the first, right? There's always give and take, alternative analysis, can you do this, can you modify this, can you amend this? That could go on for several, and thank you for acknowledging that. It isn't just you walk in that minute and boom, it's gone.
No.
So that, though, John, is a fundamental legal question, is whether or not it's fair or unfair for the process to require you now to make that appeal to a court system rather than a regulatory process at the state level. Again, what I could suggest is, if you think that is fundamentally unfair, then I would suggest, and not to put this on the city council, but because they adopt all the ordinances from chapter 1 to chapter 19, that you may want to go and present that, and you're suggesting either change that or maybe repeal it, because you are conceivably exposing people to a process that is financially all-consuming.
It's not me per se, and yes,
Well,
I'm
whether
involved,
it's
but
you,
what if
but-
the individual who wants to put an in-ground pool in an undisturbed area, and you say no?
So-
Their only avenue is to go to Superior Court. That's the fact.
But-
Their
but
only
I'm-
avenue is to go to Superior Court. Well, why can't we go to DEP?
Sure.
Why can't we fight it out there?
Yeah, because to adopt an ordinance under the Commonwealth of Massachusetts, the outcome of that, because the way the rules are written, is that you go to Superior Court. But I would also offer this, and not to put my friend on the spot here, is when one files with the Conservation Commission under the Wetlands Protection Act, I would ask how many of those are actually ever denied. Can they? Of course they can. Of course they can. But the question is, if we were to establish the number of applications that the Conservation Commission has decided upon, or processed applications, from the time the Local Wetlands Act, Local Wetlands Protection Ordinance was adopted, I would look at the forensics. Is it 1%, 2%? So we would look at it. So conceivably, whether or not you go to DEP, there's no guarantee you're gonna get, right? You're not
No,
guaranteed a superseding order conditions.
But you're gonna get a quick decision.
Well, you're gonna get a quick decision, and I understand your concern is you are having counterparts review it. I get it. Well, but again, John, right, the statutes are written where members of the community are allowed to be appointed to serve on these volunteer boards.
Absolutely.
Appointed by a mayor or board of selectmen, subject to confirmation, say, by a council. So, but that's the process. So you're getting at the core of that process?
Yes.
And again, it's a great philosophical question and why, but out of fairness to everyone here, I don't know if this is the forum for that discussion or that debate.
No, but for the unsuspecting homeowner who thinks that they may still be able to do everything that they want in their backyard, they have limitations. And so I would say, why not at the very least make all homeowners exempt from it? And that's my opinion.
Yeah.
But I think there's going to be an undue burden because not everyone is a developer like myself
Sure.
who has the resources to go to land court and to fight and go to the Superior Court and fight. And I wouldn't advise it because even going to seek a superseding order of conditions and to
Cost you
back up what Scott said, it's still
Cost
on
you
Park
more.
Street. My cousin spent $30,000 to fight that.
Yeah.
And she prevailed in the end, but it still was at a pretty large expense. And I'm going to get out of here quick. I just also wanted to say, I want to thank Mike Davis for, sitting down, being a gentleman, having a discussion with me, even though we're at opposite sides of the spectrum. It's nice to see that two individuals can be bipartisan and hope, work to find a better outcome for all. And I do appreciate the effective date because there are many of us who are far along in the process of seeking our permits and then, whoops, one day, tomorrow or whenever it's voted on, not tomorrow, but after the public hearing, it's voted on, it's effective. That doesn't sound very fair to me, but.
So as environmental planners, we do what we need to do.
I appreciate
But
that.
we're also very sensitive to the public. We're not looking to stick it to anybody or whatever. We sincerely think this is a good idea and in practical terms, and that was one of the points I raised here, we want to advance to you tonight, a practical application. I said those words at the beginning, and we think that's only a fair thing to do.
I appreciate that.
All right, John.
Thank you both.
And John, if you got any more questions or concerns that come up between now or whenever, especially about this, please let us know.
Will do.
Always happy to talk to you, meet with you.
Me too.
Get into healthy
Both the
debate.
gentlemen, I appreciate it.
All right, thanks, John.
So folks, we're at almost 9 o'clock. We kind of said at 8:30. So we're going to wrap this up. I want to say thank you very much on behalf of Nick. Thank you very much for coming. I appreciate all the questions. We tried our darndest to be able to answer those questions, whether or not we did or didn't. Of course, I'm not going to debate that. Hopefully we did. Keep the questions coming. We're going to do this one more time before the public hearing. I hope to see you at the public hearing. We're going to be wrapping up, but if you still have any questions as we leave, you're more than welcome to speak with us. So, again, thank you very, very much.
And please feel free to email, call us. Happy to schedule a meeting too if you want lengthier discussion on this. Always happy to make ourselves available. Thank you all.